Mr. Jones, I'm going to tell you one thing. Mr. Jones, I'm going to tell you
I'm not allowed to object. I'm my own counsel now. I'm allowed to object, ain't I? It's only 3 years.
When I'm talking, you do not talk over me. Do you understand that? Because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years. I don't need
Mr. Jones, I don't care what you want with regard to that. I'm following procedure, and this is what...
Absolutely. Here's a tightened up and more engaging version of your text. All right, guys, today we've got a real piece of work, sovereign citizen, who apparently thinks the law is just a suggestion. This guy is straight up arrogant, cocky, and honestly, just flat out irritating. He's already serving 4 years for armed robbery, but now he's facing another 3 years for assaulting an officer while in prison. This guy is on a whole other level and not in a good way. Let me know what you think. Is he dealing with some kind of mental health issue? Or is he just completely clueless about how any of this works? Either way, buckle up. This court hearing gets heated. Let's dive in.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through Waiver, I've been through jury trials. I've done all this before.
Do you go to law school?
No, I do not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
That's
you
3
won't.
Years, man. It ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life, and you never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. I had to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm
That's
sorry.
Cool.
It's not cool. You're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
Absolutely. Here's a smoother, more impactful rewrite that keeps your tone and energy intact. Yeah, gotta do what you gotta do, right? Even if that means taking an extra 3 years in prison when there's a clear opportunity to get that reduced. Makes total sense. Not this guy is already doing time for aggravated robbery, and now he's staring down another 3 years for assaulting an officer. But here's the kicker: if he goes through with this jury trial and gets convicted, he's looking at 13 years total. 13. He keeps repeating 3 years, 3 years, like that's all he's facing. But in reality, it's way worse. At this point, it honestly feels like he's collecting prison time, like it's a game. And based on his attitude in court, yeah, a guilty verdict seems almost inevitable. Let me know what you think. Has this guy completely given up? Or does he seriously not understand what's happening? Let's jump back in and see how this plays out.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what I got to do.
Ms. Martin does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is
We'll
what
see
I'm
that,
doing
but that
right
will be
now.
tested.
I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
Just add it to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions and picking the jury and everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay, there's the other problem. Because you are in custody, you have shackles on. You want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. You're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. Know a little bit more than most. Ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question.
I
Are you
understand
aware of
the
any?
question.
Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume,
Correct.
at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand
Correct.
that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
Of course, here's a cleaned up and engaging rewrite while keeping your original tone and message. This dude seriously has no clue. Like, not even a little bit. I swear, if he were facing 10 years, his reaction would probably be, A, it's just 10 years. Like, bro, do you even realize you only get one life? 3 years is a massive chunk of time. And yet, he's out here acting like it's no big deal. Am I overreacting, or is 3 years actually a long time? Because honestly, if you think back 3 years ago, it feels like a whole lifetime. That's a lot of time to just throw away. What's really scary is how some people just don't take the law seriously, especially guys like this, who walk into gas stations, pull a weapon, and start threatening people like it's nothing. What part of that sounds normal to anyone? At this point, I have to wonder if there's something going on mentally, because this behavior is way out of touch with reality. And if you've got a free public defender giving you solid legal advice, maybe consider listening for once. Anyway, let me know what you guys think in the comments, because I'm genuinely baffled by this.
There may be possible mitigating circumstances. Do you understand that?
Huh? No, nope, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3
Ms.
years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something. If, when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
You try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental, it will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay? But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. You understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Can I get a few minutes? I use the bathroom anyways.
Few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do.
Take him to the bathroom.
This one. Let's dive back in. Here's a polished and engaging rewrite that keeps your tone, energy, and skepticism intact. At this point, it almost feels staged. Like, seriously, how does this guy come up with this level of nonsense? He was so dead set on representing himself, and now suddenly he wants to think it over. Come on, man. It's giving major stall tactics. I don't know. Maybe I'm wrong, but what do you guys think? Is he actually being sincere about reconsidering, or is he just trying to buy time? Because if I were the judge, I'd be thinking he's looking for any excuse to delay or maybe even bolt from the courthouse. Let's not forget this dude literally held up a gas station, got hit with 10 years, and now acts like an extra 3 years is no big deal. He doesn't seem to care about much at all, and that alone raises some serious red flags. Honestly, I can't tell what's going through his head. But one thing's for sure, he's unpredictable and law enforcement better. Keep their guard up. Let's get back into it and see how this all plays out.
Can I say something real quick, Your Honor? I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your
So
security of this.
how I'm supposed to use the bathroom in
Sir?
cuffs? How I'm supposed to be able to wipe myself in cuffs?
All right.
Your officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right,
so I can
let's
wipe.
get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself, obviously, is a logistics issue. Since you are incarcerated, the shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now you can stand up at that table without your legs being seen, because for the record, there's a skirt, or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.